Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today we are going to talk about whether or not your step-parent can affect your inheritance. Before I get into that, I want to give you my contact information so that you can reach out with any questions. You can find me on my website at www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can follow along on social media at Amanda Rocha Law. So this question about whether or not your step-parent can affect your inheritance is going to largely depend on what kind of assets your parent and step-parent have, both separate and together. First of all, California is a community property state. I have podcasts, videos, blog posts, lots of information about what is community property. But just very quickly for the purpose of this video, if you are married in California, anything you earn or obtain during your marriage outside of an inheritance is going to be community property. Anything you had before your marriage is separate property. It could turn into community property, and that is why your inheritance could be affected. So I'm going to give you a hypothetical situation. Let's say you were born and by the time you were a young child, your parent remarried, and everything that parent basically has and owns has been purchased together with their new spouse, who is your step-parent. They didn't come into the marriage with any separate property, they didn't own a home, they didn't have any extra money, and they haven't had any inheritances along the way when they pass away. In that case, you probably are only going to receive something that your step-parent decides to pass along to you, because more likely than not, your parent is going to own only community property, and community property passes to the other spouse when the first spouse passes away. Now, in another scenario, if your parent goes into the marriage with separate property, and that can be personal property or real property, meaning a house or land or something like that, that property may remain separate in nature throughout their marriage. And if that's the case, when your parent passes away, unless there's an estate plan in place saying otherwise, you should receive a portion of it. The percentage of that portion is going to depend on other factors that I won't get into in this video, but it's possible that during the marriage, your step-parent can influence your parent to disinherit you from certain things that you would otherwise get. So it is really important to know that if you and your parent think that you should gain inheritance to a certain item, that there's an estate plan in place to make sure that happens. Because otherwise, if there is no estate plan, you'll get a portion of their separate property, not the entire thing. And you likely won't see any of their community property. And as I said before, if they decided to disinherit you by creating an estate plan and writing you out on purpose, that's a whole other thing. So what you want to make sure you do is be very clear with your parents about what it is you think is going to happen, and ask them, what are you leaving to me or to my siblings or whatnot, so that you're aware ahead of time. You can all be on the same page and you're not accidentally disinherited from something just because it was jointly owned, and while one parent thought it was going to happen, the other didn't. If you have any specific questions about this, I would be happy to answer them. You can find me on my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can follow along on social media and send me a direct message at Amanda Rocha Law. Thank you.